Good afternoon, friends, and as part of this particular course on media laws and ethics, I intend to discuss with you about law and jurisprudence today. What is law in general parlance? Now, if you really try and go deep into it, you'll find that law is nothing but it's the codified morality of the society. In other words, it reflects the moral judgment of the society at large. So, even if we define that, even if we say that the statutes and the laws which gives us, certain rights, they are primarily the genuine concern of the state to protect the individual rights at the same time to uphold the societal morality. That's why what I already told you was like it is an embodiment of social morality. At the same time, it also reflects about, or it talks about the individual rights and liberties. Now, however, if we analyze it, the foundation of law is primarily not the right of the individual, but essential requirement of community life, because law arises on the premise that men live together and they can only live together. Now, broadly speaking, law is, if we have to go to a definition or particular conceptualization of law, it is nothing but a notional pattern of conduct to which actions do or ought to conform. It depends largely on social values, accepted norms, and behavioral patterns of a particular society at a given time. Now, it is a codified norm at the societal level, a violation of which attracts sanction in the form of punishment, or it can also attract something like compensation. But then when it comes to the Indian legal system, what is law from Indian perspective, or what is law for us as citizens of India? Now, Article 13(3)(a) of the Indian Constitution provides that law includes any ordinance, order, bylaw, rule, regulation, notification, customs, or uses having in the territory of India the force of law. Now that means, anything and everything which is being defined by the Constitution, even Constitution is a source of law. And we are also going to discuss about different sources of law, as part of our second lecture. But what I mean to convey to you here is that the whole idea of law it's quite a broad idea, it's a broad concept, and we need to understand that from that perspective. Now, where from this whole idea of law evolved? Is it that law arises before and community arises later, or is it community arises before or the law arises later? I think it's a very interesting, interesting idea altogether to look at. Now, the existence of law presupposes a community. That means, if we believe that we live in a community, itself binds us in some set of unexpressed norms, unexpressed values. That is the whole genesis of law. So what I said was, the existence of law presupposes a community. Implicit in the notion of community itself is the acceptance of a set of socio-ethical values so fundamental to the existence of very community itself. That what I mean to say here is that the societal norms is something, it is a prerequisite for any community living, any community, and when we codify those set of societal norms or the socio-ethical values of the society, that becomes law. Now, how law in India progressed, where from it evolved? Now, if we go back to the ancient India, and then we look at the medieval India, then we come to the modern India, we find that it has got an interesting, history. It has got an interesting evolution, evolutionary, angle to it. Now, during the ancient time, there was nothing called law. there's something called religion. So in Indian context, it is the religion which is I would say the initial or the first thing about law in Indian context was the religion or the Dharmasastras. So Dharmasastras, they govern the society at large or the community at large, and it was, now in the whole of the ancient period, it was primarily by religion or different rules being framed or different rules being found as part of different Dharmasastras. Now if we then after coming from the ancient, if you look at the medieval history, you find that it was more or less the Islamic law or the Sharia and the colonial period. You know, what we find during the British period, it was the primary time when the codification and the consolidation of numerous legislations or numerous laws in India happened. That means laws in the modern sense of the term, it only became possible during the British time because they realized that they needed to codify the laws. Now I'm not going to discuss about what were the objective of codification, why laws were brought in. It has got a different story altogether. But then the fact remains that the codification of laws in the modern sense of the term in India, it happened during the British period, and in the ancient period it was Dharmasastras, and during the medieval period it was the Islamic law. Now during the ancient period, if you look at, you find that there's an interesting phenomena altogether. The interesting phenomena was that initially the man used to retaliate for anything being anything wrong being done to him or her. But then that individual revenge that was replaced by a kind of community revenge. It's not that one would retaliate against the other, but the community would retaliate or community would take cognizance of that. Now what happens was that while doing so, they were more bound by certain ideas of religion. That's why they're thinking that anything doing against religion is something called sin. But what happened was that in the process, the people at the higher strata of the society, they started exploiting others in the name of religion, and the religion aspect was replaced by something called the kingship, because the realization was that perhaps that the community life, which was governed by the whole idea of religion and sin and the morality and things so on and so forth, were not sufficient. And then the whole institution of kingship came in, and the institution of kingship was again, it was believed that king could do no wrong, because it was believed that the king derived divine powers, somewhat like king was somebody sent from the heaven. He had all the divine powers to rule. But even when the kingship was prevalent, the realization was that at times there were arbitrary use of powers by the kings also. And that particular aspect led to the realization that, or led to the understanding that, there was perhaps the necessity of state. And when the state became a necessity, what was prerequisite for the institution of a state was something called law. And that's how we feel that the law in Indian context particularly it happened. It became a phenomena in Indian society. Now, how does one define what law is? Because as media students, we need to have this broad understanding of that different concepts, different purposes, different ways the law has been defined from time to time. Now let me read out for you some of the very important definition of law given by some of the important jurists altogether. But then you'll also understand that all this definition can be grouped under two headings. One is that it says that laws are nothing but abstract body of rules, and second is that it is nothing but a social process for compromising the conflicting interests of man. That means in one particular stream of thinking, or the school is emphasizing on law as an abstract body of rules. On the other side, you find that they are more looking into law as a societal process. Nevertheless, let me read out for you some of the important definitions. Now, I quote, law may shortly be described in terms of a legal order tacitly or formally accepted by a community. It consists of the body of rules which are seen to operate as binding rules in that community, backed by some mechanism accepted by the community by means of which sufficient compliance with the rules may be secured to enable the system or set of rules to continue to be seen as abiding in nature. It was given by a jurist called Patton. The next, I quote, laws are proposition commanding the doing or abstaining from certain classes of action, disobedience to which is followed by some penalty or inconvenience, unquote. It was given by Holland. Now, I quote, law may be defined as the body of principle recognized and applied by the state in the administration of justice. It was given by a jurist called Sarmah. And next, we find that law may be defined from different approaches, as I initially told you, was that it has got different ways of looking at it. Number one is the basis of the definition that we find is the region, religion, or ethics. That is the primarily why law is being defined. Is it defined on the basis of some region, religion, or ethics? That is the natural law approach. Second is it can be defined in terms of source, whether the source lies in custom, precedent, or legislation. Third, it can also be defined in terms of its effects on the society at large, and fourth, by the methods of formal expression or application. And finally, law can also be defined in terms of the ends that law intends to meet. That means, as a very conceptual level, what we need to appreciate is that there are different ways of looking at the very concept of law. If somebody defines it as an abstract body of rules, somebody may define it in terms of what actually law is trying to or striving to arrive at, and another school or another theorist can also define in terms of what is the basis of law, where from it originated. All this way law may be defined, law may be looked at. That is what I wanted to bring to your notice here. Now, next important thing that appears when it comes to law, there is something called jurisprudence. Now, what is that jurisprudence all about? Well, now let us see what is jurisprudence and how do you define jurisprudence. Now, as the very term jurisprudence stands, juris implies law or legal, and prudence implies, prudential implies knowledge. So jurisprudence is the science which gives us knowledge about law. Now, the one aspect is what the law, and the other aspect is the law. So there is a difference between what law and what the law is. Now, jurisprudence is more concerned with the law rather than what the law is. I think that makes the whole distinction between law and jurisprudence. Now, there is one jurist called Sarmah, according to whom jurisprudence is the investigation of law in a systemic manner into three different aspects. And what are those three different aspects? Number one is the legal exposition, Number 2 is the legal history. And then number 3 is the science of legislation. Now let me explain to you what are these 3 aspects. What do you understand by legal exposition? That means when we look at a particular law, I give you one example of anything, say for instance, the law relating to sedition in India. Now the legal exposition would be not only that we look at where this particular aspect of sedition been covered under Indian laws, that is under Indian Penal Code, but then why was this particular provision? How this particular provision have been operationalized from time to time, and how the judiciary has looked at, or how the judiciary has interpreted this whole provision of sedition from time to time. And not only that, what have been the concerns regarding retention or abolition of the provision relating to sedition under the statutes by the successive government in power from time to time. So that means we don't only try and see what is the provision of law, but also try and understand how this law has been operationalized from time to time, and why this particular law was brought in, and what is the relevance of this particular law in the present context. Now next is the legal history. That means, when we look at the particular law, we try and trace the very evolution or the very genesis of this particular law. To give an example, the Information Technology Act in India, which was brought in the year 2000. Now, if we try and see the legal history of information technology, somehow or somewhere we find some relevance of it or some similarity of similar laws in foreign countries. Though India never had a law on information technology, but there existed some similar laws in the foreign countries to do with information technology. Third, the science of legislation. Now, the science of legislation is all about how scientifically the laws in India are brought in. That means what are the procedures being followed, and to what extent I would say that the science of legislation is also about how effectively the laws reflect the hopes and aspirations of the people, and what is the mechanism in place whereby these particular hopes and aspirations are taken into account and they are given an expression to these laws by the legislature. That means the whole lawmaking process is taken into account. Now, if you combine these 3 aspects, it's very interesting, jurisprudence, legal exposition, legal history, science of legislation, all together, it takes us far ahead from merely looking at what the law is. The problem in our society is that we try and see the law only. We do not try and see the larger context of it. Larger social, economic, political, historical, compulsions or historical reasons for who is the particular law has been brought in, and under what all political, social and economic compulsions or necessities the law has been operationalized, and what is the impact of such particular law in a larger context. Now, what I mean to say here is that the jurisprudence gives us a scope to look at not only what the law is, but it helps us to go beyond that to try and understand why a particular law, how it has been operationalized, what has been the effect, and what is the broader social, economic and political context under which this law is in force. Now, according to another jurist called Julius Stone, jurisprudence is nothing but lawyers' extraversion. Now, what do you understand by extraversion? That means, from a jurisprudential perspective, When we look at law, we do not look at law as only from legal point of view, but we try and see what is the impact of law from other disciplines other than law. That means, as I have already stated, how does economics influence on law? How does history influence on law? How does politics influence on law? And also, how does law influences on economics? How law influences on polity at large? How law influences on sociology at large? This is what Julius Stone referred to lawyers' extraversion when he said that jurisprudence is also lawyers' extraversion. Now, after having said that, friends, let us go to the different schools of jurisprudence, because it is essential for us to understand about different schools, to understand the relation of law with that of society, or to understand law and its relation with media well.